Good evening to the aspirants of the All India Bar Examination 17th Cohort 2023. The exam is going to be held on 5th February 2023 if it is not postponed. Yes, anyone can unmute and read what I posted on the screen.
Welcome to the aspirants of AIBE-XVII-2023 to the multiple choice questions and answers company law. It is compensatory online class on the date of 26th January 2023 and conducting today on 29-1-2023 at 9:10 p.m. to 10 p.m. by Professor Dr. Mohammed Saheb Hussain, Professor of Law.
Thank you very much. Now, without the wasting the time, shoot to the All India Bar Examination 17 Cohort 2023 Company Law Multiple Choice Questions. Be ready for the first question to shoot. The 213 Act is divided into dash chapters containing dash sections as against dash sections in the Companies Act 1956 and has dash schedules. A. 26, 470, 658, 7. B. 27, 470, 658, 7. C. 28, 470, 658, 7. D. 29, 470, 658, 7. Which is the right answer?
Sir, option A, 26, 470, 658.
WRONG. Second option.
Sir, option C, 28, 470, 658, 7.
WRONG. The present act containing 29 chapters and 470 sections as against the old Company Act of 1956 having the 658 sections and the present one is having the schedules 7. So the right answer is
D.
D is the right answer. D for Delhi is the right answer. Supplementary question. What is the act number of the Company Act 2013?
18, sir.
Yes, it is 18 Act number of 2013. The second question. The business sector is the dash of many countries' economies, particularly in India. Option A, vertebrae. Option B, backbone. Option C, pillar. Option D, support. Fill the
Sir, option A,
appropriate.
vertebrate. Sir, option A, sir.
WRONG.
Option B, sir.
Option B is the backbone. The business sector is the backbone of many countries' economies, particularly in India. Third question. There are the company acts in India, which is not. Number 1, the Company Act of 1913. Number 2, the Company Act of 1956. 3, the Company Act of 1976. 4, the Company Act of 1996. Option A, 1 plus 2. Option B, 2 plus 3. Option C, 3 plus 4. Option D, 1 plus 2 plus 3 plus 4. Before 2013, there are only 2 acts are there. I am giving the hint. What are the 2
Option
acts?
B, sir. 2 plus 3.
WRONG. Before
Option D, sir.
2013, there are only two acts.
Sir, option C, 3 plus 4.
WRONG.
Sir, option D, sir. 1 plus 2 plus 3 plus
No,
4.
There are, I
option A,
said
1
it
plus
only
2.
two acts, I said.
Sir, option A, 1 plus 2.
Option A, 1 plus 2 is the only two acts. There is the Company Act of 1913 and the Company Act of 1956. If you see the feedback, the Company Acts of 1956 was enacted on the recommendation, of course, 1950 for the Corporation of the Independent India. With the enactment of its legislation 1950C, the Company Act 1913 was repealed. The fourth question, who drafted the Company Act? The Companies Act of 1956 was enacted on the recommendation of Dash, set up in 1950. A. Bava Committee. B. Baba Committee. C. Vibhava Committee. D. Baba Committee.
Option D, sir. Baba
Option
Committee.
D is the right answer. In the last time also I asked the same question, but in a different style. Perhaps the answer is the same. BHA, BA Baba Committee has recommended. Fifth question. Which statement is the wrong statement among the four statements? A. The Government of India is introduced to regulate the functioning of companies in India. B. The Company Act 2013 aims to improve the quality of corporate governance and protect the investor from fraud. C. The Act also seeks to promote the competition in the marketplace and increase the corporate transparency. D. CSR made obligatory. One statement is wrong. All the three are right. As per the Company Act 2013. Shoot. Participants.
Sir, option B.
WRONG.
Option C, sir.
WRONG.
Sir, option D,
D.
CSR obligatory.
If I say yes,
A.
why it is wrong? CSR is not obligatory, it is a mandatory. CSR is not obligatory, it is a mandatory. So, I changed the mandatory to the obligatory. So, that is the wrong statement for the fifth question. Is it clear?
Yes, sir.
Yes, sir.
Sixth question. As a result of this expansion, a proper and well-formed corporate law was established, which includes the monitoring all legal and external affairs, problems such as dash, and so on. Number 1, international trade issues. Number 2, investigations. Number 3, litigations. Number 4, fusions. Options: A, 1 plus 2 plus 4, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3.
आम्हाला भी नको ना सालानपुरा दादर.
Please mute. I'm hearing your house sound. Among the 1, 2, 3, 4 options, shoot the A, B, C, D. What happened?
Option C, sir. 1, 3, 4.
Option C, 1, 3, 4, you want to say. WRONG. See, the question is, it covers all the three, but not one out of 1, 2, 3, 4. And the right answer is 1 plus 2 plus 3, and it will not cover fusions. It covers the international trade issues, investigations, litigations. I changed the fusions. Actually, it is merger and acquisitions. Merger and
Okay, sir.
acquisitions also there. These are all dealt over there. But I changed to the fusion. I made it. And hence, the right answer is only 1 plus 2 plus 3 is the right answer. Seventh question. Which one is the correct option among the 4 options? Here I made A, B, C, D. The Companies Act of 2013 introduced new concepts supporting enhanced disclosure, accountability, better broad governance, better facilitation of business, and so on. B. The Companies Act 2013 introduced new concepts supporting the enhanced disclosure, accountability, better board governance, better facilitation of business, and so on. C. The Companies Act of 2013 introduced concepts supporting the enhanced disclosure, accountability, better board governance, better facilitation, business, and so on. D. The Companies Act of 2013 introduced a new concept supporting enhanced disclosure, accountability, better board governance, better facilitation of business, so on. And now you make it what I asked. What I asked? Correct option among the 4 options. Which is the correct option among the 4 options? A, B, C, D.
Option A, sir.
Option A is the correct answer. The reason is the Companies Act 2013 introduced a new concept supporting the enhanced disclosure, accountability, better board governance, better facilitation of the business, and so on. If you happen to see the B, here what I say, introduce the new concept supporting enhanced disclosure, accountability, better
Same.
board governance. What I changed
Both are
something. What I changed something here.
No, sir, you didn't change anything in A and B.
No changes. I did not do the changes. Let me check it what I wrote here. Okay. I think I was changed. I was in the impression. Okay, no matter. Let us see the accountability. Better board governance. Okay. Okay, now what is the wrong in the C?
There is no new, sir. New concept must be there, but you just
Yes.
wrote concepts.
Yeah, that is wrong. What about the D?
After better facilitation of business, you didn't wrote and so on. You
Yes.
just wrote so on.
Yes, now the right answer is A, B. I think I did not change the B. The Companies Act. No, I did something. I don't know what. Ah, yes, I did it. I know, I did not do it. No, I did it.
Full stop, sir.
Yes.
No full stop after so on.
See, Companies Act, comma 2 and 3. Actually, it is a Companies Act. It is written in this style.
Right,
Of
right.
2013 is written in the exactly there. So that is I made some changes over there. Okay, A is the right answer for that one. Now the 8th question. The court decided that removing a person as a chairman of the companies is not a subject matter under section 241 of the Companies Act unless it is proven to be the oppressive or harmful. Sections 241 and 242 of the Companies Act 2013 don't specifically give reinstatement authority according to the court in the case of dash. A. Cirrus Investment Private Limited and other versus Tata Sons Limited and others. B. Tata Consultancy Services Limited versus Cirrus Investment Private Limited. C. Royal British Bank versus Turquand. And D. A.K. Bindal versus Union of India.
Sir, option A, Cirrus Investments Private Limited versus another's versus
WRONG.
Option C, sir. Royal British Bank versus Sir Quant.
WRONG.
Option B,
Sir,
sir.
A.K. Bindal versus Union of India. Option D.
WRONG.
B, sir.
So the
B.
right answer is Tata Consulting Service Limited versus Cirrus Investment Private Limited. It is decided in that case law like that. Ninth question. Anyone can unmute and read?
Dash of the Act states that every company having the specified net worth, turnover, or net profits must establish a CSR committee. Option A, Section 135, B, 135(1), C, 135(2), D, 135 of 3.
Shoot.
Option A, sir, Section 135.
WRONG.
Sir, option D, section 135(3).
WRONG. The right answer is B. B for bag. Section 135, subsection 1. See, you have to pick from the sections. Because the same question I saw somewhere, they wrote only 135. But other option 136, 137, 138 is there. At the time, 135 is the right answer. But when it specifically mentioned 135 class, subsection 1, 2, 3, at that instance, right answer is section 135, subsection 1. 10th question. The definition of the word allocation as defined under section 75, subsection 1 of the Companies Act 1956 as challenged in the court. The court determined that reissuing the forfeiture share is not the same as allotment of the share as defined in section 5. 1 of the term allotment refers to the company acceptance of share offer was served in the case of, it's about the old act 1956. A. Seth Mohanlal versus Grain Chambers Limited. B. India versus Delhi Gymkhana Club. C. Sri Gopal Jalan and Company versus Calcutta Stock Exchange Association Limited. D. Shanti Prasad Jain versus Kalinga Tubes Limited.
Sir, option
D,
C.
sir.
If you say the option D, Shanti Prasad Jain versus Kalinga Tubes Limited, WRONG. If you say
Sir,
the
option C.
If you say the C, Sri Gopal Jalan and Company versus Calcutta Stock Exchange Association Limited means that is the right answer for the old Act of Company Act 1956. 11th question. The major highlights of the 2013 Act are given below. Which one is odd man out? Which is not relevant? A. The maximum number of the shareholders for the private company is 200. The previous act was at 50. And B. The concept of single person company. C. Company law appellate tribunal and company law tribunal. D. CSR mandatory.
Option C, sir. Company Law Appellate Tribunal and Company Law Tribunal.
It is there. In the 2013 Act, it is there.
Sir, option A.
It is there. The maximum number of the shareholder for a private company is 200. The previous is only 50. They increase the number here.
D, sir.
CSR is mandatory because at the time I wrote the obligatory. But actually it is a mandatory.
B.
See, I made a small correction there. The concept of a single person company. No. The concept of a one person company.
Yes, sir. Yes, sir.
It is the
Yes, sir.
one person company, not a single person company. Even if one
Yes, sir.
person would be there, he can form a company and he may be the director.
Yes, sir.
So that is the 2013 new concept. Yes, 11th question. Yes, where we are? Oh, I have gone. Yeah. 12th question. In dash, the Supreme Court held that because questions of right, title and inserted in shares as a result of nomination were pending before a civil court which had ordered the status quo in relation to the Supreme Court matter, it would not open to a shareholders whose title to the shares had been disputed and who was not eligible to maintain the petition under the section 244 to agitate matter relating to the deputed shares by way of a petition for oppression and mismanagement, including the seeking a waiver of the requirement under section 244 of the Company Act. A. Aruna Oswal versus Pankaj Oswal and others. B. Smruti Shreyan Shah versus the Lok Prakashan Limited and others. C. Dhananjay Mishra versus Diantron Service Private Limited and others. D. Sirius Investments Private Limited and others versus Tata Sons Limited and others.
Option A, sir. Arun Oswal versus Pankaj Oswal and others.
Yes, it is Aruna Oswal versus Pankaj Oswal and others. It is the relevant case law which is there. May I know the what technique that he used it?
Just guessing, sir.
Just guessing. That means even though not knowing the answer also you can shoot it what I want to say. Okay, which option is the correct option? A. CSR is a management concept whereby the company integrates social and conservational concern into their business operations and interaction with their stakeholders. B. CSR is a management concept whereby the companies integrate social and environmental concern into their business operation and interaction with their shareholders. C. CSR is a management concept whereby the companies integrate social and environmental concern into their business operations and interactions with their stakeholders. D. CRS is the management concept whereby the companies integrated and social and environmental concern into their business operation and interaction with their stakeholders. So now I made the four options. I drag it to the next page. You can see that four at a time. Now you can decide which one is the right, what I said, correct option among the A, B, C, D.
Option C, sir. C.
You are right. Option C is the right answer. The reason is the wrong in the A is CSR is a management of a concept whereby companies integrate social and environmental concern into their business operation and interaction with their, I wrote stakeholders. No, it is the same thing.
Conservational, sir. You used conservational instead of environmental.
Okay, yeah, I made it. Conservational concern, and here is the environmental concern. Okay, that is the mistake. Come to the matter of B. CSR is a management concept where companies integrate a social and environmental concern into their business operations and interaction with their what I made the stakeholders.
Stakeholder, sir.
Okay. There I made the shareholders and here the stakeholders. What about here the D?
CRS, sir. Instead of CSR.
Not CSR. I made the CRS. So that is the mistake. So in the A I told you conventional. Conservation is inserted in place of environmental, hence A is wrong. And the shareholder is inserted in the place of the stakeholder, hence B is wrong. And CRS is made instead of CSR, and hence D is wrong. So the right answer is C.
Yes, sir.
14th question. Yes, anyone can unmute and read 14th question?
The CSR provisions applied to a company
No,
registered.
14th.
Sir.
You are
Social
350.
responsibility programs can boost employee morale in the dash and lead to greater productivity, which has an impact on how profitable the company can be. Option A, office. Option B, factory. Option C, workplace. Option D, workroom.
Option C, sir. Workplace.
It is the workplace is the right answer for the 14th question. Yes, anyone can unmute and read the 15th question.
The CSR provisions apply to the company registered for a charitable purpose under dash of all the Companies Act 2013. Option A, Section 6. Option B, Section 7. Option C, Section 8. Option D, Section 9.
Option C, sir. Section 8.
Section 8 is the right answer. The CSR provisions apply to the company registered for a charitable purpose under Section 8 of the Companies Act 2013. Yes, now the 16th question I read. When was the latest amendment in the Companies Act 2013? A. 24th March 2019. B. 24th March 2020. C. 24th March 2021. D. 24th March 2022. Latest amendment in the Company Act.
24th March 2020, option B.
WRONG.
Option C, sir. 24th March 2021.
If you say option D, 24th March 2022, wrong. If you say option C, 24th March 2021, it is right. So according to the MCA notification GSR 207E dated 24th March 2021, the amendment to the Schedule 3 of the Companies Act 2013 mandates the company to round their financial statement of according to their total income. That is the modification they did to Schedule 3 in the 24th March 2021. Is it clear?
Yes, sir.
17th question. Merger or amalgamation are inserted under the dash of the Company Act 2013. A. Section 231. B. Section 232. C. Section 233. D. Section 334. Should.
Option D, Section 234.
WRONG.
B, sir. 232.
WRONG.
Option A, 231.
WRONG.
Section C, 233.
The section C is, excuse me, 233 is the right answer. 18th question. The Company Act 2013 has introduced the concept of the dormant companies. Dormant companies are those that have not engaged in business for a dash years consecutively. A. 1. B. 2. Option C. 3. Option D. 4.
Option B, sir. 2.
Option B is the correct answer. 2 years. If the 2 years the company did not make any business, then that company is called dormant company. 19th question. Due to notification NFRA, India is now eligible for the membership of the IFIAR. What is the full form of it, please? A. International Forum of Independent Audit Regulation. B. International Forum of Independent Audit Regulators. C. International Freedom of Independent Audit Regulators. D. International Forum of Independent Audit Regulators.
Sir, option A,
Sir, option
International
B.
Forum of Independent Audit Regulation.
WRONG.
Sir, option B, sir. International Forum of Independent Audit Regulators.
Option B is the right answer. International Forum of Independent Audit Regulators. Here I have given International Forum of Independent Audit Regulators is the right answer. But other places I changed it here and there. Am I right? In the D, I wrote adult. And in the C, International Freedom of Independent, I wrote some other thing.
Freedom, sir. Instead
Freedom,
of
I wrote
forum.
it. Actually, it is a forum, not freedom. So, 28th question. Which statement is the wrong statement as per the salient features of the Companies Act 2013?
Use kare mommy. Kannada
See, you are speaking. I could hear your voice, Rukhaya. Mute.
Sorry, sir.
Which statement is the wrong statement as per the salient features of the Company Act 2013? A. The whole process of rehabilitation and liquidation of the companies in the case of the financial crisis had been a time limit. B. The Act makes the mandatory for the companies to form a CSR committee and formulate the CSR policies where you are. The formulate the I don't know where was it. Okay, let me read the first. The whole feature of the rehabilitation and the liquidation of the companies in the case of the financial crisis has been a time limit. B. The Act makes the mandatory for the company to form a CSR committees and formulate the CSR policies for certain companies. Mandatory disclosures have been made with regard to the CSR. And C. Listed companies ought to have one director to represent small shareholders as well. And D. There is no provision for the search and seizure of documents during the investigation without an order from the magistrate. One is not connected, wrong. Other three are very much connected. For the statement of the features of Companies Act 2013.
Sir, option odd man out. D, sir. Option D.
Wrong. There is a provision for the search and seizure of document during the investigation without an order from a magistrate. Yes. As per the new act. Everything is correct. But I committed a mistake at one place I removed. For instance, if you see the A, the whole process of rehabilitation and liquidation of the companies in the case of the financial crisis has been made a time limit. It is not a time limit, it is a time bound. Is it clear?
Yes, sir.
See, only one mistake there. It is a time bound, it is, not time limit. So that is the appropriate word which they used in the salient feature of the Company Act of 2013. Yes, 21 question. In which chapter dash registered valuers only one section is from chapter dash till chapter 1 to this chapter? I thought there is only one section in one chapter, but later I found no, there are 3 chapters in 3 sections are there. But anyway, let us see. The beginning first chapter, where one section is there, from the beginning of the chapter 1 to here. Only one section. In which chapter? Answer is did you understand the question first?
Sir, option A 15.
Yes, I thought only 15 is there. Okay, here the answer is right. And what section? 247. Again, I found only one section is there in this chapter also. And that is chapter is 25. Again, only one section. Companies to furnish the information or statistics. And the section is 405. And again, I found in chapter 17, again I found only one chapter, one is there. That is the same thing, 247. And again, supplementary in chapter 26, Nidhis, only one section is there, 406. Power to modify acts in its application to Nidhis. So total 3 chapters are there. Each chapter one question, one section is there. Now supplementary question. What is Nidhis? Anyone? What is Nidhis? Nidhi means a company which has been incorporated as a nidhi with the object of cultivating the habit of thrift and saving among its members. Such companies receive deposits from and lend its member only for the mutual benefit. That is called the nidhi. So now let us go to our, where it is gone. Yes. So that is the nidhi. Now next question. How many sections omitted under the Company Act 2013? Option A, nothing omitted. B, only one. C, only two. D, only two sections are omitted. I say omitted, I did not say repealed. Participants, are you there?
Yes, sir.
Shoot.
Sir, option D.
Wrong. WRONG. Anyone can take the screenshot when the members are maximum for the attendance.
Option
Third
A,
question.
sir.
Yes, please continue.
Option A, nothing omitted.
No, WRONG, wrong.
Option B, only one.
Only one section is there which is omitted in the entire Company Act of 2013. Now the second question, which section it is? Section 10, Section 11, Section 12, Section 13?
11.
11th section. If you just happen to see the Bare Act, you could easily make it out. There is only the 11th, excuse me, only the 11th section is omitted from there. Next, 25th question. In India, the first concept of ultra-virus was noticed in the case of Dash, where the plaintiff had purchased the 600 shares in a company and the defendant, that is the director of the company within parentheses, had also purchased some shares in the same company. The memorandum of the company did not allow the members to sell or purchase any shares of their company. So number A, Kotla Venkataswamy versus Ramamurthy. B, Jahangir R. Modi versus Shamji Ladha. C, A. Lakshmanamurthy Mudaliar versus Life Insurance Corporation. D, Ahmed Said versus the Bank of Mysore.
Option B, sir. Jahangir R. Modi versus Shamji Lodha.
It is a Jahangir R. Modi versus Shamji Lodha case law. A director could not purchase his own shares. Result of virus. Okay, if I ask you what is the secret, how did you know it? Did you read it or just you shoot it?
No, sir. I happen to read it somewhere.
Okay. 26th question. In Dash, the court observed that the third party may not take advantage of the doctrine of ultra-virus acts in order to avoid the performance of the obligations voluntarily undertaken with the full opportunity to know the extent of the company's power before entering into the transaction. A. Anglo Overseas Agency Limited versus Green. B. Shiva Shanmugam versus Butterfly Marketing Private Limited. C. Dr. A. Lakshmanaswamy Mudaliar versus Life Insurance Corporation of India. D. Bell House Limited versus City Wall Properties Limited.
Option B, sir.
Option B is the right answer. Shiva Shanmugam versus Butterfly Marketing Private Limited is the right answer for this question. The court observed that the third party may not take the advantage of the doctrine of ultra-virus acts in order to avoid the performance of the obligation voluntarily undertaken with full opportunity to know the extent of the company's power before entering into the transaction. So these are the things which I designed with my own brain, not taken the copy and paste. No, I read it. I used my own intelligentsia to make you confused. Then I made it. So these are the today's company law. If you happen to see my company law, the old videos, I don't think that there would be a similarity except one similarity that I found it. One question I asked, that is Baba committee. Except that one, you find that all the things are new here. So now I would like to show you, yes, because I already kept it here, right. No, this is not, this is Microsoft. I put it here. No, that is a company. Company Law Bear Act, that is, I want the Companies Act, yes, it is here. Oh, it's taking so much time to open. The Companies Act of 2013. See the arrangement of section, chapters. I did not ask you today. Chapter 4, share capital and debentures. And chapter 5, it is the acceptance of deposit by the companies. And chapter 6, registration of the charges. Chapter 7, management administration. At one side, part A, I read the chapters. In the part B side, I read its title. Then I said, match the following. So I did not prepare today that such a questions. To my knowledge, I earlier prepared such a questions. So this time I avoided it. But I took it somewhere, some points. For instance, if you see that there is not a single capital A is there in the entire company law. See, if you happen to see from A, one capital A or two capital A or three capital A, there is not a single capital A or B is there. That means for the sections, the same sections not amended and not inserted with another section. That is the reason you could not see here anywhere capital A or capital B or capital C in the entire company law. Did you observe it? See, I am scrolling, but at one place it is there. 76A, here it is given. 76A capital. So I can form a question in the Company Act, which section added with the capital A. Then I will give the option 74 section, 75 section, 76 section, 77 section. Then the right answer is the right answer is
76.
yes. See, this is one. Again, I will show you anywhere added capital A in the entire. No. 149, 150, 151, 194, 196. And here also no. 270, 274, 314, no. 354, 357, 366, and 393, 394, 396, 407, then 426, 447, and only one section where the capital A is added. Please, there is a possibility. If the examiner like me, definitely I will concentrate on those questions which are very peculiar in nature to ask and which is not covered earlier. So please note the point. There is maybe possibility that only one section is added in the company law to say the capital A. And please find out in which amendment it is added. Second supplementary question. See, when you add it, you add only in the amendment. Am I right? Am I right?
Yes, sir. Yes, sir.
Yes, sir.
So please check the amendment also. For instance, I did not frame the question here like this. 447 punishment for fraud, 448 punishment for the false statement, 449 punishment for the false evidence, 450 punishment for the no specific penalty and punishment unprovided. I write the part A 447, 448, 449, 450 and the part B, the explanation I write here. Then I will jumble it. The explanation. Again, I will ask you, match the following. Or I will make the as it is 447 punishment for the fraud, but I will jumble punishment for the false implement, I make it down, and the punishment of the false evidence is make it up. Then 450, I write the same thing. Then mismatch the following. Then I will give the 2. A, 1 plus 2. B, 2 plus 3. C, 3 plus 2. And 4, 1 plus 4. And I made only 2 jumbled. That is 2 plus 3. Am I right? Mismatch.
Yes, sir.
See, I am showing you the way a question can be framed, the way that you can shoot it. It depends upon your feeding to your brain. If you feed to your brain in multi angles, in x-axis, y-axis, z-axis, in 3-dimensional, and all the perspectives that you can frame it, you can shoot it, and without your knowledge, you can shoot the right answer. That is the technique.
Yes, sir.
So, I
Sir.
am not giving you a fish. I am teaching you how to angling, means fishing. A-N-G-L-I-N-G. Angling means fishing with a stick. So that you can earn yourself, you can score yourself the good marks. And keep in the mind how you frame the mind and you become in that way. And don't keep the mind with taking the books, taking the barracks. I said, no barracks, no books, no nothing. Whatever the pattern I taught you in a different angle, even more intuitional way also I taught you. Like adding the amendment capital A and how many sections are there in the chapters and how many are omitted and how many are repealed and how many are schedules and which schedule is amended. These are all the angles I covered it. That means I covered more than the All India Bar Examination people perspectives. So the pattern of the exam which is there in the All India Bar Examination, the way I teach it, and I covered more than the All India Bar Examinations. And you can notice it. You definitely will notice it. Such a questions also I framed. And you will be established. You will be astonished to say how I framed the question. The reason is, I framed this question not from now. I framed this question from the 15th cohort. From 15th cohort, I taught 2 times. 16th cohort, I taught 2 times. And I taught the All India, PG law set in the examination also, the various subjects I taught. And I taught also for this APCJ. And in the different angles I covered it. That means I framed so many questions on one subject or many subjects, because there are 19 are there, but actually it's a 24 for the All India Bar Examination. So I covered in all aspects of it, and where the common subjects also there, then I covered in a different angles which I did not cover earlier. If you happen to see my YouTube channels, and you may see that my repetition is very less, and you may notice it. Every time I will come with the new ideas, I will come with the new way of asking the questions, then I will frame in that manner. So set up your mind. What I want to say is, set up your mind in such a way, I can shoot the way it will be asked in the All India Bar examination, and getting 40 marks is a little finger business. I repeat, scoring the 40 marks is a little finger business. And hence, go with that attitude. I am sure, of course, I would like to write to the Bar Council of India, 40 is a very less marks out of 100, to my knowledge. Because people, those who did not read, even by hearing or watching my videos, several people got through the 40 marks. And when they passed it, they wrote to me, "Sir, to be frank, I did not read anything except watching your videos. Your videos made me to understand the subject in such a way, and I can shoot it even though I don't know the answer. Because you taught us in that way, in that perspective, in that mode, in that angle. So I'm sure that you will also get it. But don't entertain the idea that, sir, keeping the books. No, no books, no nothing. I framed the questions depending on the various factors of the All India Bar examination, then APCJ and TSCJ and PG Law Set and LLB also. So I framed in the many angles the same subjects in a different fashion. And if you go through that my earlier also, I am sure that you will get it. Now the Cisco WebEx is very kind enough. Actually the time is now 10:02. Of course I started by 9:10 or 9:12. At any time it will stop it. If you want to ask any question, you can ask me. Yes? Any questions to be asked? Sir, give me your handout, sir. We would like to read it. Everything what I framed is, I shared with you. And if you say that we will read before the examination, don't read the before the examination. Keep your brain so calm and comfortable. And stop reading from the night. If the exam is on the 5th February, on the 4th night, you stop everything reading. Don't read anything before going to the examination. Even after going in the campus also, don't read and don't watch my videos. Keep the mind settled down first. Once the mind is settled down, you can see all the images of mine which I taught in the class. And if any question is framed over there, it will reel, the machine will reel over there, go back, and the read-only memory will make it out. And immediately you can shoot the question even though you don't know the answer, because I developed you in such a way. And some answers, in once reading only you can know that which is the right answer, because some of them may be collided of similar nature of my question framing. Any question in the pattern of my question framing is there, without any hesitation you will tick it. Without any having second thought you tick it, because your mind already pursued that thing in your brain. And whatever the pattern which I told you, I told more than the AIB pattern by using my own intellectual brain in the shooting from the different angles. And hence, follow that one. And the tomorrow is, what is that tomorrow? Tomorrow is 30th. And 30th, what is that? Labor and industrial laws. The 4 questions. So please read the labor and industrial laws. I believe the old only, not the 4 which are new. Am I right?
Yes,
New
sir.
4 laws, still they are not start teaching. So now you have to follow only the old labor laws, what is they given in the question pattern. Those things only you have to follow it. And let us come tomorrow with the same timings, having at least 25 to 30 questions of a different nature in the labor and industrial law. By that, I would like to stop it. If you want to ask any question, you can ask me, because at any time the Cisco WebEx may close. Yes?
No questions, sir.
Okay, now I will stop my today's, the meeting end for all the participants. Still 5 minutes are there, but now I would like to end the meeting. Jai Hind.